Hello and a very warm welcome to Frank Talk on Bharata First. I'm Frank Rausan Pereira and we are here to discuss a very important topic, a subject that has been in the news for at least the last decade has been dominated by the IBC. So with regards to IBC 2.0 and particularly focusing on real estate and infrastructure, that's what we are going to discuss here on the program today. And to do that, I have a stellar panel. The chief guest of our program today is Justice M.M. Kumar, the first president of the National Company Law Tribunal and the former Chief Justice of the Jammu and Kashmir High Court. Welcome, Justice Kumar, and thank you for being here. It's a real pleasure.
Thank you so much.
Also with us on the program is CMA Deepika B. Prasad, who is an insolvency expert and founder of D. Prasad Advisory, and her main focus is infrastructure. Welcome, and thank you for being here. Also with us on the program is CMA SN Anjum, ex-CFO and insolvency professional. He's an expert in real estate matters and looks at real estate very, very closely. Thank you to all my guests for being here on Bharata First. I'd like to start with you, Justice Kumar. It's really an honor, first and foremost, to have you here on the program. Let's discuss, your role as the first president of the NCLT with regards to infrastructure and real estate. What were some of the biggest challenges and issues that were faced as far as this particular sector is concerned?
Thank you very much, Frank, for having me. The biggest challenge generally is the timeline, including the real estate and infrastructure sector. Of course, Insolvency Bankruptcy Code require to finish the corporate insolvency process in a specified time. This timeline has been changed from time to time. But I will say that what contributes to the delay can be taken care of by adopting better strength. The number of judges should be much more than what we have now. The delay in the appointment of the judges on the NCLT bench and better infrastructure. If you see the benches functioning, say, at Delhi, the Delhi bench is in a building which was left by CBI. So better infrastructure can be provided to the Delhi NCLT, that is principal bench, which is the face of the National Company Law Tribunal. Second is how to control the builders from diverting the funds of the home buyers to other projects. Beginning was made by enactment of RERA section 421D of the RERA. No mandates that 70% of the amount received from the home buyers or from even the banks should be deposited in escrow account, and it must be accounted for and ensure that it is spent on the infrastructure alone. Then, in order to empower the home buyer, the home buyers were included in the definition of financial creditor. And in the judgment of the Supreme Court in Pioneer Urban case, Justice Nariman has observed that home buyers, right from the day one, they were financial creditors. However, the amendment which was brought in 2018 by amending Section 5, Subsection 8, Clause F, is clarificatory in nature. Therefore, it is considered to be there right from the beginning. As a result, the home buyer became member of the COC, and they were able to control the decisions which were being taken by the COC. Then the home buyer rights also came before the Supreme Court.
Right.
In a public interest litigation. In that litigation, this subvention scheme, which is based on tripartite agreement between the builder, bankers, and the home buyers, there was a nexus found by the Supreme Court in 2-3 sample cases. The nexus was, in the agreement, there was a clause that the home buyer will pay when first slab is put, when third slab is put. I am only taking hypothetical example.
Right.
But the banks, without the knowledge of home buyer, kept on releasing the money to the builders in cases where even the project has not started. So that also, now the matter has been referred to CBI for investigation to expose this nexus, that how the banks could have, in violation of the tripartite agreement, released the funds to the builders, and it resulted into huge delay in delivering the possession of the flats to the home buyer.
Right.
So the Supreme Court also in our Valley's case has taken care of home buyer's interest in a big way. Then the home buyer, then another judgment which is very important, that is Rainbow Paper 2022. In that judgment, the authorities like Noida authorities or VAT, they were considered earlier as operational creditors. Operational creditors in the waterfall under section 53 are at a very low pedestal. They do not get anything virtually.
Sure.
But by this judgment in Rainbow, they have been upgraded to the status of secured creditors. As a result, in the waterfall, their status go very high. And this is also game changer. Authorities like Noida, in Gunoida versus Paramjit Singh Soni, 2024, specifically the rights of authorities like Gunoida have been recognized as a secured creditor. So this is also a development, evolving law, because earlier they used to be considered as operational creditor. Despite all this, the Supreme Court in cases like Supernova has passed order saying under Article 142 of the Constitution, which provide for doing complete justice, that they have set up committees, and the committees have been given the power to manage the affair of the company, the infrastructure company. Secondly, zero period has been declared. Bank cannot realize any money from the home buyers. The developer cannot. Likewise, Noida authorities cannot.
Sure.
So these are the my opening remarks. I would also like to point out that in the liquidation, if the company goes in liquidation, then the home buyer is nowhere. That is also a tragic aspect.
Absolutely, absolutely. Thank you, Justice Kumar, for so beautifully putting those aspects into place and letting us know exactly where we stand as far as this particular sector is concerned. Talking about challenges and problems, delays are one of the biggest challenges, and let me bring in Deepika B. Prasad into the picture now. Studies have shown us with regards to delay that if a project goes beyond 330 days, that there is a loss of a minimum of 15% and so on and so forth. So when it comes to infrastructure projects, idle infrastructure projects where the machines rust, where there is delay, decay, there's so many other aspects that are, there to it, and there's so much of value erosion as well that takes place. How would you look at that particular aspect?
So first of all, thank you, Frank, for bringing me on to this program. I'm really feeling very happy to have this opportunity to discuss about this matter, and I'd like to bring about the ground level realities which the RPs would face and which are actually happening in the infra projects. Now, as far as the manufacturing companies are concerned, the assets are kind of preserved, but the infra projects are very different compared to the manufacturing companies. Here there is idle machinery, there are contracts that are in the middle and they end up. And then, there are issues related to liquidity. There are there is board, there is government organizations, there is the held up payments which are not coming back. Then the subcontractors or the other stakeholders in the ecosystems who are equally affected. And an unbuilt road, or a half-built road, or a half-built transmission line, or a half-built, real estate project would actually be nowhere. So this is one part which is there for the infra project. So here we need to bring about a change in the understanding, or rather the perspective from value erosion to value preservation. And how do we do that? First of all, I really believe that the most important thing in infra projects is to bring all these stakeholders in the ecosystem on board in the insolvency process, as in we need to go and have a kind of meetings with the board, with the government departments, with the subcontractors, with the employees, with the other stakeholders who would come in. Because the most important thing that generally happens in infra projects is the lack of interim funding and the lack of further approvals and the licenses which would end. Therefore, it becomes very important for an RP to execute those projects. The only way to have a kind of value preservation in the infra projects is continuity. So it becomes very important for the RPs to ensure by all means that the continuity of the projects happens. So this can happen if the other stakeholders come on board, and somehow the other stakeholders, since their stakes are also big, and they are also the ones who would actually go for big losses. So they are the ones who can come in and support in the interim funding. For example, you can go to the government departments. If each government department has to re-tender their project, the cost is too much. And of course, the loss is for everybody, and it's a national loss. So it is in the interest of everybody. It is in the interest of the government, the stakeholders, the subcontractors, the corporate debtor, that we ensure that the continuity of the projects is maintained, and that they, within their system, as of now, in the given infrastructure, in the given ecosystem of insolvency, they are the ones who can come in and together try that the continuity is done and that the stalled projects are completed. The same is true for real estate sector also. It is the stakeholders who are coming in. This is still, we are waiting for the IBC 2.0 to come in, when of course we are hoping to have some more changes, and we are really looking forward to changes that would actually lead from a value erosion perspective to a value preservation perspective.
Absolutely.
This is what I believe.
Absolutely. Yeah. Very rightly put and very succinctly put as well. Let me bring in SN Anjum into the picture as well right now. You know what Deepika Prasad was suggesting is that continuity is very important, and also what is important is bringing all the stakeholders together to ensure that stalled projects are taken care of. Talking about stalled projects and real estate, SN Anjum, I'd like to ask you, how is this issue of stalled projects being addressed and being resolved as far as the real estate sector is concerned?
Okay, thank you. Thank you for inviting me here. So, first of all, I just on the stall project before that, so challenges that is being facing in the real estate sector. So one must say, apart from the time constraint, as sir said, so apart from that, the liquidity is the biggest challenge that I have seen in my experience. So in the maintaining in the project within that particular time frame given under the IBCs, and maintaining the liquidity in that period, and getting resolved is very challenging. That is what is primary important that I could see. And secondly, basically multiple litigations that is being there. So many litigation, n number of litigations being there, and how to handle that litigation within particular period. So that is the most challenging. See, if one RP as a resolution professional, if they can focus and they can stress and they can identify those litigations critically, and they can find out the means and ways to resolve those litigations, no? But whatever means it says, so that is what the real, breakthrough can come. So that is what my experience I could say on that. As far as stalled projects are concerned, so basically, that those projects can, under the IBCs, can come into the insolvencies, can be resolved through the new resolutions process, through the getting the new developers on board, and getting it mitigated under the COC mechanism. So that is what it is being there. But just to resolve that, we have to see how quickly we can give the positions to those unit holders who are basically the unit holders of that. So that is what the focus that I could always carry. How quickly I can give the positions, by whatever means and says. There are a lot of challenges to give that. So somebody can say, no, let's wait for the resolution plan to come, and then only that position can be given. So, and in the resolution plan, even if it comes, but it's getting approved under NCLT, it takes their own sweet time because a lot of litigations are going on. So I have seen in cases where it is years and years being there, although 330 days mandate period is there. So that at the end, home buyers are sufferer. So my focus is that to see, even if there are multiple projects in one particular corporate debtor, I identify those projects which are being stalled and which can give quicker OC occupancy certificate. We can give the deliveries, the position, those units. I focus on that. So I take all means, I convincing to the authorities, meeting with the landlord, meeting with the COC individuals, and meeting with the home buyers through air. So I took all the means to get it convinced why what I am talking about is more appropriate, and how quickly it can resolve your issues. It may not resolve issues at one go for all the projects, that's very true. But it can be resolved one by one in that given time frame. So that is why my focus is always. So in that way, we took all directions and get the stall project as quickly as possible. That is what my experience is all about.
Absolutely. Thank you for taking us through your experiences really as far as the real estate sector is concerned. And the most important part as far as real estate is concerned is the home buyer, and getting possession for the home buyer is the most important and the fundamental aspect really. Justice Kumar, let me come back to you now. Let's go into specifics. You spoke about Amrapali in your opening remarks. Off air we were speaking about JP as well. The IBBI is pushing for mediation. Could a mediator have solved the JP or the Amrapali issue or crisis faster than the NCLT? And what do you think about the role of a mediator?
I think I would say yes. IBBI is correct in thinking that mediation must be introduced at pre-litigation stage and even post-litigation stage. You see, in India, court-annexed mediation is already in place because of Section 89 Code of Civil Procedure. And mediation centers are functioning in various states. Punjab and Haryana, I know. Mediation is a process where both the parties, financial creditor and corporate debtor, are in a win-win situation. If you see, most of the resolution, the financial creditor like banks, they have been able to realize 40%, 38%. But mediation, since it takes place at the pre-litigation stage, and there can be possibility of realizing more than 60% if mediation is successful. Secondly, why mediation should be preferred? A corporate debtor knows the real value of its assets. Once it comes under the corporate insolvency resolution process, various financial burdens come on the assets, as have been observed by the co-panelist. So therefore, that is a preferable course. Thirdly, once mediation is successful, the matter comes to an end. There is no appeal to the National Appellate Tribunal or to the Supreme Court. So those delays are completely curbed. And in one matter where one-time settlement was possible and the banks have proceeded in JP matter, it is on record. But because of direction from RBI under Section 35A, that course could not be adopted. Even one-time settlement is a good course to follow. That is also resolution in a different way rather than mediation. So in all these 12, 1 dozen dirty cases as they are known, mediation was possible, and in all other cases, you see, basically corporate debtor and the financial creditors are on dealing terms with each other for the last many years.
Right.
So there is a fiduciary relationship, a relationship of trust. So on the basis of their past relationship, these cases can be fit to go for mediation. Unless there is a criminal matter, some misappropriation has taken place which cannot be part of mediation process.
Then it's a different case altogether.
That is a different case altogether. So I would say that mediation must be started, and if it happens, if you study, IBB has released the data. Because of IBC, Section 7, 9 and 10, at pre-litigation stage when the notice is issued, even at that stage, large number of cases are solved. That also goes to the credit of IBC.
Absolutely.
Then, when application under 7 filed, thereafter, before admission, they are resolved. Huge success. But there can be, even post-admission, there can be resolution by depositing the 100% and with the consent of 90% member of the COC shareholders, this can also be resolved. But mediation is much more effective, much more cost effective in terms of delay and time.
Perfect. Absolutely. Absolutely. All right. So let me bring in Deepika B. Prasad once again into the picture now, and we're talking about specifics. We are going into these particular aspects of, we're talking about Justice Kumar spoke about Amrapali and spoke about JP, etc. Can you share a real life experience or your personal experience in a matter with regards to infrastructure projects, and what was the final outcome?
Yes, definitely. As RP, I would like to bring about some operational issues, some issues which definitely are incumbent upon the RP to take action so that, the value is preserved and that the corporate debtor sees the light of the day. I would like to share with you experiences of two cases here. One is a cement industry, being RP of JP Cement Corporation Limited, and also a road building company called Parivartan Buildtech. I'd like to bring about some ground level issues which need to be resolved as RP. First of all, the issues which are there include the deterioration of plant and machinery, the loss of confidence in the market, the supply chain disruption, the issues of labor, and the workforce, they also lose confidence. And then amongst all this, the lack of liquidity, the liquidity crunch is one of the biggest things. And then a disruption amongst the employees of any corporate debtor. This whole thing comes to a situation where the synchronization and a kind of a total effort is required to put everything in place so that the value preservation happens in a good way. So here I would really like to say what all steps I have been taking. I mean, just to ensure that the corporate debtors' value is preserved. That is actually bringing on board all these stakeholders, be it the labor, be it the dealers, or trying to raise interim funding from the existing sources. So here I have tried to raise funding from the dealer network, which has actually, in the form of advances. I'd like to bring here one important thing that during the CIRP, whatever cost is incurred or whatever funding is, kind of brought in, is forming part of the CIRP cost. So, of course, which is under the waterfall mechanism and also as a part of the resolution cost to be paid up as a first place. So, giving that kind of confidence based on law and based on efforts and based on the, the facts of any particular corporate debtor, we can definitely mobilize the existing resources, including the customers, including the labor, including the departments who are actually dealing with the corporate debtor, to somehow allow the funding to flow in and allow the show to go on so that the value is preserved till a resolution is found out. The biggest problem here that we feel is, coming because there is a loss of confidence amongst the financial creditors also about the corporate debtors. So there are no LCs, there are no such, non-fund based limits which are available to the corporate debtor, with the help of which, the CD can stand on its own by raising funds. So to cover up that aspect, it becomes very important that the RP makes efforts to make use of the existing ecosystem, the existing framework of the corporate debtor. Same I would like to bring about in one of these cases, like I've been talking about this road building project. Now, a half-built road cannot be of a benefit to anybody. So, trying to work out with the subcontractors, because they are the one who are going to lose. So they have to start work without getting money in the initial phase, and then working out with the departments that they have to, kind of expedite the payment timelines to ensure that the moment some part of the work is done, they release the funds so that the back-end subcontractors and the back-end people can continue their work. And I'm very happy to say that in these cases, I have been able to run the operations, manage the continuity of the corporate debtor without seeking any kind of contribution from the lenders, and still running the show so that the value preservation is done. Because at the end of the day, as RP, every single person in the ecosystem is a stakeholder. And I'd rather say as an RP, I'd rather dare to say that it is my religion to protect the interests of all these stakeholders. And that is the duty of any RP, to protect the interests of all these stakeholders. So I believe that this is not about, a balance sheet solution. This is about going out in the field and executing those projects and ensuring that, a dialogue is created with every stakeholder, and the results are there for my value maximization, which is the real intent of the law. Yeah.
Absolutely. Very rightly said, and thank you for sharing personal experiences as far as infrastructure projects are concerned. Since we are here as an Anjum, let's also talk about the role of an IP really as far as stressed assets are concerned, and what are the tools that are available under the IBC to handle or to deal with such stressed or stalled projects.
Yeah, thank you. So the tool in the sense that we have to find out the mechanism how to resolve the issues, right? So there is no fixed tools kind of, and we have to see under the IBC mechanism whether through by any means, whether it is through mediations, the issue can be resolved, or through continuing the projects and see the viability and maintain the going concern, the value maximization can be done. So RP has to do out-of-box thinking. There is no one-way solution to this. The out-of-box thinking to me comes in different projects, different means. One of the projects where the villas are there, high-end villas of 10 crore rupees. Okay, so here the people have been suffering since last 10 years. Then I could see that, we have to see the balance sheet, as the balance sheet gives a lot of amenities of that particular corporate debtor, where you can find out the means and solutions to that. If I see the balance sheet, and I could see that one of the cases where few crores rupees lying in somewhere, which was there in last 4 years, but not in litigated manner. So whenever I took over, I just find it out, and then subsequently I resolved that litigations under the CRP mechanism by dealing with the authorities, by dealing with the banks, by dealing with whatever means in says, and got it released. So that is a big relief. So that is what the COC members see, the value additions. As a RP, we have to see how to add values in the ecosystem. whether it is through balance sheet, in balance sheet, out of balance sheet, whatever means it is. So wherever the stall projects are being there, so you have to find the tools to identify the liquidities, first of all, not to take any contribution from the COC members ever, because they themselves are sufferers in so many years. If you ask the COC members the further contribution, they may contribute. But as an RP, I feel always bad to go to the COC and ask for additional money. Then I never do that. I always see how to maintain the going concerns out of the COC's pocket, and then see what best value maximization can be done. I am happy to say that I have been successfully done in so many projects, housing projects where fund can be arranged, either through the debtors' contributions, means home buyer contributions. Very difficult to convince home buyers to contribute further, because they have been not been in possession of the units in last so many years. In addition to that, you are asking money from them. Then you have to convince, once you pay the money, I am assuring you on writing that I will give you delivery in so many period. So if on your assurance, so that is why if they have the confidence on you, they are going to pay. And in my case, they have paid. And with their money, I have delivered them their positions and their handover, and they are happily living in now in last 4-6 months. I have handed over at least 30-40 villas to those people where they are happily and living now, and where they were not in positions last 10 years because of litigations. So this is what I am thinking, that out of box thinking one have to do, and then only you have to find out ways and means to get it resolved and do the positions as early as possible, and at the same time keep the going concern, and at the same time keep the value intact for the COC members, so that value maximizations can be done for the COC when the resolution happen as a whole.
Absolutely. So there is no one-fit-all approach really as far as this particular issue is concerned, and it has to be taken up on a case-to-case basis is what SN Anjum is suggesting. Thank you for your views as well. And time now for a quick rapid fire. And Justice Kumar, I'd like to start with you. The rules are very simple. 5 questions per head, and we are going to try and finish all those 5 questions in 1 minute each, in either one sentence, one word, or yes or no. So no more than one sentence. Okay. So I'm going to start with you, Justice Kumar.
Okay.
So rapid fire round starting now. If RERA and IBC clash over a project, who should have the final word?
IBC.
Okay, fantastic. Is fixing one building while the rest of the company stays alive legally sound?
No.
Okay. Can a court-appointed professional really finish a highway better than a contractor?
Contractor.
ठीक है. And should real estate cases get longer grace period than standard factories?
Longer period.
Okay, so that is yes. And if a buyer takes over a stalled project, should they be 100%, should they get from the old tax rates, or from the older problems, should he be defunct of those problems? If a new player comes into the picture, what happens to the old taxes?
The dues which are validly leviable, they have to be paid.
Okay, fantastic. That was a lovely rapid fire round. We finished in less than a minute. Let me bring in Deepika B Prasad into the picture now and get the rapid fire going. Is resolving a 100-kilometer toll road harder than fixing a 2,000-kilometer or 2,000-unit housing complex? What is harder? Housing complex or 100-kilometer toll road?
Both have their own issues. I would not say, it is...
So it's difficult to pick.
It is difficult to pick.
Okay, fantastic. Does the IBC need technical judges alongside legal judges for infrastructure projects?
Yes.
Should a bridge or power plant be allowed to stop working just because the owner went bankrupt?
No, because there are so many stakeholders.
Okay. And how do you value an incomplete, dam or airport in a shifting economy?
Well, it is very difficult to say how to value that, because the most important thing is how fast we can, rebuild it, how fast we can, put it back in order. That is how I would value it.
Okay. And is mediation the secret weapon for solving India's infrastructure backlog?
Yes, to a large extent.
Fantastic. Okay. That was your rapid fire round. We finished in less than a minute. It's now time to bring in SN Anjum as well for his rapid fire round. Are you ready?
Yeah.
Okay, fantastic. The new rules allow you to hand over keys during the process. Is this a logistical nightmare?
As a nightmare, but very interesting to handle and very challenging. But I like that. I love it.
Okay, nightmare, challenging, and it's good to have it in place to challenge you. Okay,
Yes.
fantastic. Where do you get the last mile money when the banks have already walked away?
So that is what innovative thinking that I said. We have to think innovatively. We have to find out the ways and means. And I know that our means it, and we have to find it out.
Okay. Does having one representative for 1,000 plus buyers make your meetings easier or louder?
No, it is easier, I would say.
Okay, easier, not louder. Okay. And if a project is only 20% complete, is it better to finish it or just sell the land?
No, not sell the land. We have to finish it up. So how to finish that? IP has to come some innovative ideas and put up before the COC.
Finish it. Okay. Yeah. Should local authorities be forced to register flats even if old dues are unpaid?
So that is a very case to case, but we have to see on a case to case basis. There is no straight answer to that.
Okay, no straight answer to that. That was your rapid fire round. Very
Thank
well
you.
done.
Thank
All
you so
three
much.
of you,
Thank
great rapid fire round. Thank you for sharing your views as well. Time to get quick closing concluding remarks in about a minute each on where to go from here and what next. Starting first with you, Justice Kumar, if you can have the mic. So where do we go from here? What next and what's the best way forward?
I think the best way forward is mediation must be made mandatory at the pre-litigation and post-litigation stages. I will go with the thinking of IBBI. It's a good thinking. Strength of the National Company Law Tribunal and NCLT must be in proportionate to the cases which are listed before them. Not the 63 members who are now dealing with, they were good for under the Companies Act, dealing with the 241 cases, merger or striking of the companies. These 3-4 types of cases used to be there. But IBC has added huge workload, so somebody will have to relook at the strength. The mechanism of the administration in NCLT has to be made more effective. According to the judgment of the Supreme Court in 5 judges, Union of India versus R. Gandhi, 2010, it was said that NCLT and NCLT are equivalent to the High Courts and Supreme Court. If the NCLT is equivalent to the High Court, there has to be permanent staff. Secondly, there has to be some discipline amongst the technical versus judicial member. You see, technical member cannot sit singly, whereas judicial member can sit singly under the law. So some differences in benches have happened that also need to be resolved formally. And the information utility shall be made more effective. The timeline can be met better. The capacity building measure should also be in place, like colloquium, and from time to time, better education for the member of the NCLT. The entry and exit point for the member should be reviewed. They should not be there for 3 years, 5 years. There should be some permanency attached to the NCLT. It should not be a tribunal for the retired people. It should be manned by a regular, like High Court judges are, a regular cadre. And the seniority list, etc., should be properly prepared. The recruitment process should also be very competitive. And above all, integrity, impeccable integrity and honesty at all levels must be ensured.
Right.
That is the hallmark of every High Court and tribunal, or all the judicial functionaries in the system. It is the soul of the judicial system.
Sure, absolutely. Very rightly and very succinctly put. Thank you, Justice Kumar, for your views. And Deepika Prasad, your concluding remarks, the best way forward.
Yes, the way forward, I'm actually looking forward to IBC 2.0. We are looking forward to the amendments that should be in place. And I'd like to bring about some highlights for the same, which are going to really impact the infrastructure sector in a big way. One is, of course, moving away from the distress which is coming, after the aftermath, to creating value during the distress, preventing the distress, and that is going to happen with the incoming of the creditor-initiated CIRP, which is going to be, be done with debtor in possession, and which is going to be rather a little preventive measure, and the disruption which is happening at this point in time may be prevented. And then I'm looking forward to the group insolvency, which is, the hallmark of the infrastructure projects, because most of the infrastructure projects are in the form of SPVs or joint ventures or other layered subsidiaries. So there is interconnectivity amongst the companies. There are interconnectivities amongst the various companies within the same group. So group insolvency will bring in the kind of differences that will ensure that value maximization happens, because it will bring in same RP, COCs coming together and trying to find out a resolution for the entire group, so that interconnectivity will be something, rather than causing trouble, it will become a contributing factor. Then I'm looking forward towards the timelines. The delay in admission will be, plugged, which is something that the infra projects, because of the delay in admission, most of the value is eroded. So this is something which I see that would come as a protection. And, while there is time, and while we are still in, maintaining the timelines, the most important aspect of all EPC and infra projects is the bank guarantees. The live bank guarantees will be honored. They will not be kind of invoked, and the lender's money will not just go haywire. So I'm looking forward to all the changes that are going to be coming in IBC 2.0, and I'm hoping that as the implementation of that would happen, and of course everything would depend upon the swift implementation of the same, and as that happens, I'm sure the economic fabric in our country will turn around completely and absolutely. So this is what my expectation is.
Fantastic.
Thank you.
Fantastic. And as an Anjum, please close the show for us with your concluding remarks.
Thank you. So here, basically, way forward is, apart from this amendment that is expected, so of course that is in pipeline, so that is being passed in the parliament soon. Apart from that, I would see in the projects where some fund needs to be arranged, in the form of Swami fund, as we know. So that needs to be strengthened, that needs to be enlarged further, so that every real estate projects can reach to them even during the CIB period. It's not after the implementation of the resolution plan. So that is being there. So how that fund can be used effectively, efficiently during the CIB period, if that can be brought in, so that we could see a lot of projects can be resolved very effectively and in a time bound manner. That's what I could see. Apart from that, we have to see how the litigation is being handled, in what form and shape, whether through these mediations or any other means, or by some mechanism where these pre-existing litigations can be minimized. So I'm sure if that's going to help a lot for the real estate projects. That is what my take from here.
Fantastic. Wonderful discussion. Thank you to all my guests, Justice M.M. Kumar, Deepika B. Prasad, and S.N. Anjum for joining me on the program, sharing your views and putting things into perspective for us. It was a highly enriching discussion. But that's it in this edition of Frank Talk. Don't forget to like, subscribe, hit the bell icon, and share the content as well. Until next time, this is Rausan Pereira signing off.
Thank you.
Thank you.